Minash-shaytanir-rajim. Bismillahir-rahmanir-rahim. Assalamu alaikum wa rahmatullahi ta'ala wa barakatuhu. It's Mustafa Bey El-Mori. I thought it would be appropriate, since this is what they call Black History Month, to revisit some pertinent legal decisions in the United States of America in regards to the citizenship and status of the formerly enslaved. So today, I wanted to open the pages on the Dred Scott case. Most people are pretty much familiar with the circumstances, meaning that one individual who was enslaved and moved to a northern territory where it was a free state, and declared himself emancipated. Later went to another state, I believe it was Missouri, and in Missouri he faced certain challenges in regards to his status. So what happens is Mr. Dred Scott alleged that he was a citizen, and that as a citizen of the state of Missouri, and that his former so-called owner had passed away, and so that ownership transferred to a family member named Sandford, and I believe Sandford was residing in New York. So Dred Scott was able to bring suit under the diversity of citizenship clause of the Constitution, and the court granted jurisdiction. He alleged that he was a citizen of the state of Missouri, and that his former so-called owner had passed away, and so that ownership transferred to a family member named Sandford, and I believe Sandford was residing in New York. So Dred Scott was able to bring suit under the diversity of citizenship clause of the Constitution, and the court granted jurisdiction. He alleged that he was a citizen of the state of Missouri. Thereafter, the response from Sandford was that because Dred Scott was a Negro, that he was neither a citizen and couldn't and was a descendant of Africans and was full-blooded African. So therefore, he could not be a citizen. So anyway, the judge rules in Scott's favor, declaring him a citizen. However, there was an appeal in the Missouri Supreme Court, and the decision was reversed. And in that monumental reversal, everything was up in the air in regards to this brother's citizenship and status and all the rights that come with it. Dred Scott's attorneys responded, basically stating that the fact that the brother was formerly enslaved did not preclude him from the rights of citizenship. And so the case goes to the Supreme Court. I think federal judge Robert Wells ruled that Scott was a citizen, and because of that, they were able to even hear the case, which is kind of funny how they play that game, right? They allow the alleged citizenship to pass muster, right, so that they could have what's called jurisdiction to actually rule on the matter, right? Dred Scott's attorney brought the case to the federal Supreme Court. After hearing both arguments, keep in mind there's 9 justices in the Supreme Court, and that after hearing these arguments, there were basically a majority opinion, 7-2, and that 7-2 was unfortunately in favor of Stanford, and the rules, and resulting in an adverse ruling from Mr. Scott. So the legendary, monumental, landmark case and the language that was derived from that case is what we're going to focus on today, inshallah. The case comes before the Supreme Court again. As I said, there were 9 judges. There was a split decision, 7-2. Justice Roger Taney was the chief who wrote the majority opinion. Roger B. Taney stated that no black, whether slave or free, could ever be a citizen of the United States. So in his view, so-called blacks were not members of the society. They were not members of the political community. They could not own property, so on and so forth. What's extra extraordinary is he also declared that the rulings that made slavery illegal in the Missouri Compromise, he declared that unconstitutional. So we have a constitutional question as it relates to our existence in the United States of America, be it as citizens or be it as property or the quasi-citizenship status that was the ultimate result of all this. It is necessary to note that Justice Curtis was a dissenting opinion, and he argued that blacks were citizens and that they had enjoyed voting rights in certain, at least I think he said 5 northern states, and they voted on Constitution ratification and things of that nature. However, it was noted that even still, the efforts were to try to limit black voting. So if you're citizens and you can vote, but you got efforts from the state to prevent you from voting, then that's kind of like in the balance, you're saying one thing, doing the other. So you bring it to a point, and the thing is that, okay, to say that so-called blacks are citizens, but to relegate them to servitude is to basically deny them citizenship. So that's kind of a circular thing going on there. And the decision ultimately that so-called blacks weren't citizens is what led to the famous or infamous 14th Amendment. So as we move to the 14th Amendment, we see that the reason for the 14th Amendment coming into existence was to grant the formerly enslaved some sort of status wherein which they can be governed and wherein which they can enjoy, certain rights. One thing that you'll notice is that whenever these discussions are taking place, it's basically centered around certain questions, right? The questions of rights to property, owning property. Property is always central. They call it vested rights. If you're a citizen, you have certain vested rights, right, in the community, in the body politic, meaning you have a right to own property, and then they talk about the life, liberty, and happiness, and so on and so forth, right? But what does that mean in regards to your relationship with the government? So there's federal and then there's state, state rights, wherein which the federal government overrode state rights, meaning the states couldn't declare who could be citizens of their state. The 14th Amendment ushered in that if you were born on American soil, then by what they call birthright, that you were a citizen of the United States. So today in the media, we see a lot of talk around this thing called birthright citizenship. This thing called birthright citizenship originated with the formerly enslaved, right? And it has been usurped in modern times to apply to all these other groups and abbreviations, right? And empower them, and really isn't doing much for the people that it was intended for. Central question as it relates to citizenship is like, what does the government actually afford the citizen, right? So it was reduced down to what they call the Privilege and Immunities Clause, and what does that actually entail, right? And then there's another thing called due process. So what they're saying is, at the very minimum, the government owes an individual the rights to due process. They have determined that due process is both procedural and substantive, right? So when you're dealing with the procedural acts, you're dealing with, okay, a person has a right to confront his accuser. A person has a right to be noticed that there's an actual claim against them and have an opportunity to prepare a defense and confront their accuser, right? That's kind of procedural. Then you have appeals and so on and so forth to go with that, right? From a substantive level, it is more, you have what they call it, it's a term they use, Latin terms. Okay, regium or regium, the regium usus, right, which is usually dealing with government. Then they have the privatum, right, which is the individual, the citizen. And then they have the publicum. The publicum, like, so someone who is doing business, providing a service, or, the corporation, right? So substantively, it breaks down into the government, the individual citizen, and the publicum, you know what I'm saying? So somebody who's building roads or highways or doing transportation and things, those type of things. So we're focused on the usage privatum, right? So what is it that the private individual enjoys under his government? And again, it boils back to, okay, right to vote, the right to own property, right? And then, the right to sue and be sued, so on and so forth, right? The same things that end up becoming usurped by big corporations, right? The right to own property, the right to sue and be sued. So these provisions have primarily been used to advance everyone except the so-called Negro, Black, colored, African American today. I know many of you have heard the speech by the Reverend Dr. Martin Luther King, where he said that he fears that he has led us into a burning house. I use the term us loosely, but into a burning house. What is the burning house? The burning house is the 14th Amendment. It's the rights and privileges and immunities that are so-called associated with that, which, as we will find out, are not as secure as one would think. A recommended reading points this out. So our ancestor, the brother Bobby Wright, goes on to give us his exegesis on psychopaths, right? He says psychopaths reject constituted authority and discipline. He says the presence of this trait in the so-called white race has grave implications for blacks who seek legal solutions to their problems. This especially applies to the blacks in the United States, who are the world's only legally, with a pen, created group. created through the 14th, 13th, 14th, and 15th Amendments, which can be repealed at any moment by Congress or declared unconstitutional by the Supreme Court. As long as these conditions exist, black people in the United States will always be legally 5 minutes away from slavery. Now, that's something very profound to say. And if you follow his argument, you will be more convinced when I provide further proof. Subhanallahi wa bihamdi. So, as I was stating before, we're going to delve into the 14th Amendment, which, for the purposes of this video, I refer to as the burning house that Martin Luther King Jr. was referring to when he said he feared he led the people into a burning house. All the rights and so-called privileges associated with the so-called African Americans' civil rights are rooted and wrapped in the passage or so-called passage of the 14th Amendment. That's kind of problematic, as we'll see as we delve into these things, because like the passage I read before by Bobby Wright about being a Supreme Court decision from being declared unconstitutional, I think it's a matter of the utmost importance that our people begin to wrap their minds around what that really means. So, without further ado, I have a legal treatise that was written by, what's the news report that was written by an individual by the name of, so you can check the references, by the name of David Lawrence, U.S. News War Report from September 27th of 1957. As follows, it states, a mistaken belief that there is a valid article in the Constitution known as the 14th Amendment is responsible for the Supreme Court decision of 1954 and the ensuing controversy over desegregation in the public schools of America. I believe that was Brown versus Board of Education. It goes on. No such amendment was ever legally ratified by 3/4 of the states of the Union as required by the Constitution itself. The so-called 14th Amendment was dubiously proclaimed by the Secretary of State on July 20th, 1868. The president shared that doubt. There were 37 states in the Union at that time, so ratification by at least 28 was necessary to make the amendment an integral part of the Constitution. Actually, only 21 states legally ratified it, so it failed ratification. Now, let that sink in. What that means is someone perpetrated a fraud on the people of the United States of America and went on to, even though it wasn't ratified lawfully by the requisite quorum, to proclaim that it had passed and push forward with their agenda that they had like a Trojan horse packed in the 14th Amendment. So, goes on to read, the undisputed record attests by official journals and the unanimous writings of historians establishes these events as occurring in 1867 and 1868. Number one, outside the South, 6 states, New Jersey, Ohio, Kentucky, California, Delaware, and Maryland, failed to ratify the proposed amendment. Number 2, in the South, 10 states, Texas, Arkansas, Virginia, North Carolina, South Carolina, Georgia, Alabama, Florida, Mississippi, and Louisiana, by formal action of their legislatures, rejected it rejected it under the normal processes of civil law. A total of 16 legislators out of 37 failed legally to ratify the 14th Amendment. Congress, which had deprived the southern states of their seats in the Senate, did not lawfully pass the resolution of submission in the first instance. The southern states, which had rejected the amendment, were coerced by a federal statute passed in 1867 that took away the right to vote or hold office from all citizens who had served in the Confederate Army. Military governors were appointed and instructed to prepare the roll of voters. All this happened in spite of the presidential proclamation of amnesty previously issued by the president. New legislatures were thereupon chosen and forced to ratify under penalty of continued exile from the Union. In Louisiana, a general sent down from the North presided over the state legislature. Abraham Lincoln had declared many times that the Union was inseparable and indivisible. After his death and when the war was over, the ratification by the southern states of the 13th Amendment abolishing slavery had been accepted as legal. But Congress in 1867 in the 1867 law imposed the specific conditions under which the southern states would be entitled to representation in Congress. Congress, in passing the 1867 law that declared the southern states could not have their seats in either the Senate or House in the next session unless they ratified the 14th Amendment, took an unprecedented step. No such right to compel a state by an act of Congress to ratify a constitutional amendment is to be found anywhere in the Constitution, nor has this procedure ever been sanctioned by the Supreme Court of the United States. President Andrew Johnson publicly denounced this law as unconstitutional, but it passed over his veto. Secretary of State Seward was on the spot in July 1868 when the various ratifications of the spurious nature were placed before him. The legislatures of Ohio and New Jersey had notified him that they rescinded their earlier actions of ratification. He said in his official proclamation that he was not authorized as Secretary of State to determine and decide doubtful questions as to the authenticity of the organization of state legislatures or as to the power of any state legislature to recall a previous act of resolution of ratification. He added that the amendment was valid. New Jersey, that the amendment was valid if the resolutions of the legislature of Ohio, New Jersey ratifying the aforesaid amendment are to be deemed as remaining of full force and effect, notwithstanding the subsequent resolutions of the legislatures of these states. This was a very big if. It will be noticed that the real issue, therefore, is not only whether the forced ratification by the 10 southern states was lawful, but whether the withdrawal by the legislatures of Ohio and New Jersey, 2 northern states, was legal. The right of a state by action of its legislature to change its mind at any time before the final proclamation of ratification is issued by the Secretary of State has been confirmed in connection with other constitutional amendments. The Oregon legislature in October 1868, 3 months after the Secretary's proclamation was issued, passed a rescinding resolution, which argued that the 14th Amendment had not been ratified by 3/4 of the states, and that the ratification in the southern states was usurpations, unconstitutional, revolutionary, and void, and that until such ratification is completed, any state has a right to withdraw its assent to any proposed amendment. What do the historians say about all this? The Encyclopedia Americana states, Reconstruction added humiliation to suffering. 8 years of crime, fraud, and corruption followed, and it was state legislatures composed of Negroes, carpetbaggers, and scallywags who obeyed the orders of the generals and ratified the amendment. W.E. Woodward, in his famous work, A New American History, published in 1936, says, to get a clear idea of the succession of events, let us review President Andrew Johnson's, I don't know why I keep saying Jackson, Andrew Johnson's actions in respect to the ex-Confederate states. In May 1865, he issued a proclamation of amnesty to former rebels. Then he established provisional governments in all the southern states. They were instructed to call constitutional conventions. They did. New state governments were elected, white men only. Had the suffrage, the 15th Amendment establishing equal voting rights had not yet been passed. Senators and representatives were chosen, but when they appeared at the opening of Congress, they were refused admission. The state governments, however, continued to function during 1866. Now we are in 1867. In the early days of that year, Thaddeus Stevens brought in, as chairman of the House Reconstruction Committee, a bill that proposed to sweep all the southern state governments into a wastebasket. The South was to be put under military rule. Now I'm going to pause right there for a minute and say this. This history, although it's primarily, about us, right, is the source for so many of the so-called quote-unquote patriot types who are typically Republican today, who typically hold the Democrats in contempt, who hold all the programs that were brought in under the 14th Amendment in contempt because of this legal argument here, right? Now, for me as a legal mind, I'm not dealing with feelings and emotions. I'm dealing with what the letter of law purports. And so I would tend to agree that it's obvious that it wasn't lawfully ratified, right? And to ignore that fact makes you disingenuous if you're claiming to want justice yourself. If you're claiming to want the law to be in your favor yourself. We have to come up with a method of operation that embraces our rights to self-determination in this struggle, right? That does not rely upon the language of the 14th Amendment. So I'll move on from there. Where did I leave off? Where did I leave off? Okay, there was that military rule. Okay, the bill passed. It was vetoed by Johnson and passed again over his veto. In the Senate, it was amended in such fashion that any state could escape from military rule and be restored to its full right by ratifying the 14th Amendment and admitting black as well as white men to the polls. In challenging its unconstitutionality, President Andrew Jackson said in his veto message, I submit to Congress whether this measure is not in its whole character, scope, and object without precedent and without authority, in palpable conflict with the plainest provisions of the Constitution, and utterly destructive of those great principles of liberty and humanity for which our ancestors on both sides of the Atlantic have shed so much blood and expended so much treasures. Many historians have applauded Johnson's words. Samuel Eliot Morison and Henry Steele Kummerer, known today as liberals, wrote in their book, The Growth of the American Republic. Johnson returned the bill with a scorching message arguing the unconstitutionality of the whole thing, and most impartial students have agreed with his reasoning. James Truslow Adams, another noted historian, writes in his History of the United States, the Supreme Court had decided 3 months earlier in the Milligan case that military courts were unconstitutional except under such war conditions as might make the operation of civil courts impossible. But the president pointed out in the vein that practically the whole of the new legislation was unconstitutional. There was even talk in Congress of impeaching the Supreme Court for its decision. The legislatures had run amok and was threatening both the executive and judiciary. Actually, President Johnson was impeached, but the move failed by 1 vote in the Senate. The Supreme Court, in case after case, refused to pass on the illegal activities involved in ratification. It said simply that they were acts of the political departments of the government. This, of course, was a convenient device of avoidance. The court has adhered to that position ever since Reconstruction days. I'm going to finish this up, but I just wanted to point out again. The wheel goes round and round. The same arguments that were then are arguments that are relevant now because the issue has not been solved. Case in point, if so-called black people were made citizens with the passage of the 14th Amendment, and this argument has been made before, there would be no need for the 15th Amendment, right? The fact that you didn't get full rights, you didn't get the right to vote, right? You got this so-called privileges and immunities, and rights to due process is what you got under so-called civil rights. But you didn't get the right to vote. And strangely enough, to this very day, if you'll recall, it wasn't but a few years back when Congress had to decide if they were going to extend the privilege of voting to African Americans for another however many years they determined to extend the privilege, 50 years, 25 years, whatever, right? That very issue puts you in the most slippery slope, jeopardy bag that exists amongst all the population in the United States of America. That's something that we need to resolve amongst ourselves, right? And that's what rights to self-determination are. You have to come to a point where you make decisions for you, and it's not about what anybody else thinks or feels. You dig? So I'll end with these final passages of the same report. I skipped a couple of lines. It is never too late to correct injustice. The people of America should have an opportunity to pass an amendment to the Constitution that sets forth the right of the federal government to control education and regulate attendance at public schools, either with federal power alone or concurrently with states. That's the honest way, the just way to deal with the problems of segregation or integration in schools. Until such amendment is adopted, the 14th Amendment should be considered as null and void. There is only one supreme tribunal. It is the people themselves. Their sovereign will is expressed through the procedure set forth in the Constitution itself. End quote. So there you have it. And that's just one. That's just one document I have that, very extensively lays out the dilemma with the 14th Amendment. And so as I started this thing saying that, you know, Martin Luther King said that he led the people to a burning house. Well, there you have it. It's been on fire ever since. And it's a shame in today's time that we haven't grown in our sophistication and understanding so that we can navigate our way out of these things. And part of that problem is rooted in this history. Case in point, once they illegally passed the 14th Amendment, you'll note that the Republican Party at the time started, employing black congressmen and so on and so forth, and they were drawing from the so-called leader class, right? And so these elected officials amongst the blacks are the first ones to benefit, right? They had the jobs, they had the pay, and they started doing things to open up accessibility for a particular class, the professional class. So, for example, it was about public education. So, teachers and lawyers, whether or not black lawyers could go to law schools. You dig what I'm saying? That became the demonstration. And once that became the demonstration, the whole talented 10th model, it set in. Bedrock, crystallized, polarized in stone, right? That's what's happening today. So that's why you have the Boule Negro, right? The so-called gatekeeper Negro, right? The Greek Negro, right? Who sits in all those places, in those professions, rooted back in these same demonstrations, and they have held those and occupied those positions from family to family to family, right? So you have a black elite, a hierarchy, right? You have a national black caucus that is just that, just a dead body, doesn't do anything, right? Haven't pushed the needle one iota since the 14th Amendment. Okay? Unlawfully, right? The whole civil rights, you see how flimsy that is because it's rooted in the 14th Amendment. So as these right-wingers and people who are concerned with law, start pulling back these things, they're attacking DEI. DEI is just a new way of saying affirmative action, right? And they just, when they took that and they said, this was unconstitutional, right? I knew the ball would continue to roll. The snowball effect was going to happen. It's going to get bigger and bigger. However, that said, I personally believe it's more of a motivation to retract some of this alphabet soup that has been included in the nefarious dealings that had to do with the advancement of the so-called black, the so-called Negro, the so-called colored, the African American, right? Those things that were being done for us have been usurped by corporations, abbreviations, and the so on and so forth, right? So I believe there's a lot of resentment about that in particular, and the whole thing about, attacking civil rights type stuff, right, is being used by those gatekeeper types to use that to say, hey, look at what they're doing, they're going to do it, but, that's just my take. Anyway, أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم أشهد أن لا إله إلا الله وحده لا شريك له له الملك وله الحمد وهو على كل شيء قدير. Mustafa Bey, Sundry Moors, Islamic Assembly. Inshallah, some of this will be of benefit for those who are concerned with right to self-determination and freedom. Allahu Akbar.
The last thing Dr. King said to me before he was murdered, Martin said, I sit here deeply concerned that I suspect we are leading our nation on an integration trip that has us integrating into a burning house. Most of the politicians I know of make promises only to walk into the places of power and then deny us. I guess part of the reason I'm here is to really look through the ravages of the Democratic Party and see if anything is really worth salvaging.